Sending out trust notices can be stressful. Here's a guide to 16061.7 trust notice procedures, plus tips, and when to get a trust attorney. When a trust becomes irrevocable, such as when a person passes away or becomes incapacitated, the acting trustee of the trust must send a trust notice to all beneficiaries that complies with California Probate Code Section 16061.7, which states, "A trustee shall serve a notification by the trustee as described in this section in the following events. 1. When a revocable trust or any portion thereof becomes irrevocable," and then it states some of the contingencies. Section 16061.7 also identifies other situations when a notice must be sent. To comply with the California Probate Code, a trustee has 60 days to send notices to all beneficiaries. The Probate Code Section 16061.7 subsection F provides the notification by trustee shall be served not later than 60 days following the occurrence of the event requiring service of the notification. The short answer is that it depends. Beneficiaries and heirs have up to 120 days from the date the notice and the applicable trust documents are served upon you to contest the trust. Or, if the documents are not included with that initial notice, then 60 days after the documents are received within the 120-day period, whichever is later, as per the California Probate Code. Subsection H, which in part provides that you may not bring an action to contest the trust more than 120 days from the date this notification by the trustee is served upon you, or 60 days from the date on which a copy of the terms of the trust is delivered to you during that 120-day period, whichever is later. This can be very confusing. Here are some hypotheticals to help clear up any confusion. Hypothetical 1. The 16061.7 notice is served on day 1. The notice includes the trust documents. Therefore, any contest must be filed within 120 days from the service date, day 1. Hypothetical 2. The 16061.7 notice is served on day 1. Notice does not include the trust documents, however. Nobody follows up to get a copy of the trust documents. Still, any contest must be filed within 120 days from the service date, day 1. But if nobody has received the trust documents, what's to be contested? Hypothetical 3. The 16061.7 notice is served on day 1. Notice does not include the trust documents. The beneficiaries and heirs follow up to get a copy of the trust documents on day 110, on which day they received the trust documents. They will then have 60 days from receipt of a copy of the trust documents on day 110 to contest, for a total of 170 days. The 110 days, which is within the 120 initial day period, plus 60 days from the time when they received those documents within that 120-day period. Again, this can be very confusing, and that's the reason why you should consult a trust attorney as soon as a loved one passes if you think there's any reason to contest. We recommend consulting with an estate planning or trust attorney throughout the process. We recommend consulting with an estate planning or trust attorney throughout the administrative process. If for whatever reason you've been named as a successor trustee and prefer to proceed without an attorney, trust forms and templates can be found online. Whether doing it yourself or with a trust attorney, the risk is simply not following proper trust notice procedures, which opens the door to litigation and claims for breach of your fiduciary duties. Working with an experienced lawyer helps reduce, if not eliminate, that risk. For higher value trusts and estates, it's even more important to follow proper procedure because the exposure is that much higher. Almost all trusts give the trustee the ability to retain counsel to assist with the administration process and have the attorney's fees and costs associated with those processes paid directly from the trust assets. What this means is that there's little to no reason not to hire counsel to help you with the administrative process. If a trust beneficiary or an heir who is disinherited under a trust would like to contest the trust contest who is named as a successor trustee, would like to contest how a trust is distributed, then they can retain a trust litigation attorney to pursue informal resolution, mediation, or formal court proceedings. At RMO Lawyers, we often recommend informal resolution strategies or mediation to avoid significant court costs and attorney's fees. It saves all the beneficiaries money and time. Sometimes, however, resolution isn't available. At that point, beneficiaries and heirs should work with an experienced trust attorney or probate lawyer to pursue their claims and achieve an equitable distribution of the trust estate. Yes, of course you may contest a trust with a no contest clause. While most states don't enforce no contest clauses, sometimes called in terrorem clauses, California is an exception. However, even where a trust has a no contest clause, it won't necessarily serve to stop a beneficiary from filing a legitimate contest as long as good cause exists to pursue the contest. The term no contest clause simply acts to put beneficiaries on notice that if they have no good cause to contest, that they may be disinherited if they choose to pursue a contest. In addition to what we've explained before, if you've already been disinherited under a trust and entitled to receive nothing from it as a result, then you have nothing to lose by contesting a trust that has a no contest clause. You've already been disinherited. You're already getting nothing. So if you contest and lose, you're still getting nothing. So there's no incentive to not contest. Too many no contest clauses fail to properly disincentivize beneficiaries from contesting by failing to give them something. Give them something that they're going to risk losing if they contest. We recommend finding an experienced trust attorney familiar with the county probate court, where the trust is located and where the action is going to be pursued. For example, if a beneficiary lives in San Diego, but the trust and the court processes are going to happen in Los Angeles, we recommend working with a trust lawyer in Los Angeles. A Los Angeles trust litigation lawyer generally will be more familiar with the Los Angeles Superior Court Probate Division and its judges versus an out-of-state or out-of-town lawyer. At RMO Lawyers, we protect people like you every day. Call or email anytime with questions or for a free consultation. We're here to help.